Good question. Is legal aid a human right or a mere luxury? Oliver's got her name all over it.
I think it is a human right, and there are circumstances where one's liberty is at stake, everything can be at stake in a case, and so yes, I do think it's a human right. Of course, the issue tends to be not so much on the cases which are clear-cut, where it is a criminal case and you could go to prison, but some of the other very important services which I think the public should have. I mean, I remember when I was on the committee of the Free Representation Unit many years ago, we had to choose which cases could be dealt with because there were so few of us. And all the other cases, people weren't represented. And I think, you know, a lot of that experience, just shouldn't be there with the sort of cases that we've been talking about tonight. I mean, it shouldn't be impossible to have legal representation. And so I very strongly agree with what you're saying.
The Tories want to repeal the Human Rights Act.
Well, I'm asked about the Human Rights Act. I don't know if
Far away.
I mean, the point we're making is not that we shouldn't have human rights, but that we should have the margin of appreciation in the British courts. Because when the Human Rights Act came in, we argued that what should happen is that the British judges should be able to make decisions about the ECHR based on British conditions and using the sort of British common sense which our courts have traditionally used. Now that's something which the government rejected. They said, no, we're not going to do it that way. Now they do it the way I'm arguing for in Germany, very successfully, and I don't see why we can't have a British Bill of Rights that's compatible with the ECHR, dealt with by our judges in accordance with our traditions, and that's what I'm arguing for.
The ECHR is based on human rights based in the UK. The whole thing was written by English lawyers.
Well, I mean, I'm very happy. I agree with you. There's a lot of the rights which are in the ECHR come from British common law, English common law, in fact, and are very much in accordance with our traditions. What I'm arguing with is the way in which our judges are allowed to interpret that law, which doesn't give the margin of appreciation which the German courts are allowed with their basic law. So I'm saying that it is true, and it's an argument which we've had in Parliament over some years, and we want to have a British Bill of Rights which is compatible with the ECHR, meets our conditions, dealt with by our judges. And I don't really see, why that is inconsistent with what you're saying.
Isn't the most exciting thing the thought that a Bulgarian has the same opportunity to win their human rights as a Brit? Isn't our obligation actually in a globalised world to ensure that as many people enjoy the same standards of human rights as we do, and better, and sometimes do is it not a fact that a British judge falls down on human rights and we are relieved by going to Europe?
Well, I mean, I entirely agree that the Bulgarians should have these rights. And in fact, it's part of our tradition as a country that, as was said, we helped to write the ECHR. It has helped in Eastern Europe, and that's a good thing. But what I'm saying is that there's no reason why in each country those rights shouldn't be interpreted by the British judges, or in the case of Bulgaria, no doubt the Bulgarian judges, in the light of the conditions in that country. It's known as the margin of appreciation. Many of you will have come across it, and it's something that works very successfully in Germany.
I would just like to say that from the young legal aid lawyer's perspective, legal aid is a critical part of the right to access to court as part of the right to fair trial. It's essential for the protection of vulnerable clients and their representation, and it's that we should be really fighting to protect in order that there's access to justice for all and proper equality of arms in cases of abuses of power by the state and so on.
George, firstly, yes, Emily hinted that there are only 15 rights in the European Convention of Protocols. One of them is the right to a fair trial. And therefore the implication of that is that for all of the trials that are covered by the Convention, you have to have equality of arms. And secondly, if you're interested in this subject, we had a fascinating debate last Monday in the House of Commons on human rights. Looked at it on the web, looked at it anywhere else. It is, as people were muttering, true that judges here actually do have a margin of appreciation. The Tories have got into a terrible muddle about this issue to do with the British Bill of Rights. There isn't a single right in the European Convention of the 15 that they would take out, and they would want to add some in. So why they don't start with the European Convention, just add a few, which would be lovely, I have never understood.